love someone else, one must first learn to love theirself. So let's tap into that frequency. I vibrate on the frequency of self-love. Yes, I vibrate on the frequency of self-love. I vibrate on the frequency of self-love. Yes, I vibrate on the frequency of self-love. I vibrate on the frequency of self-love. Yes, I vibrate on the frequency of self-love. I vibrate on the frequency of self-love. Yes, I vibrate on the frequency of self-love. I accept myself for who I am, and I make an honest effort to become better. I accept myself for who I am, and I make an honest effort to better myself in every way. I said I accept myself for who I am, and I make an honest effort to better myself in every way. I accept myself for who I am, yes, and I make an honest effort to better myself in every way. I accept myself for who I am, and I make an honest effort to better myself in every way. I better myself in every way, yes, I better myself in every way. I better myself in every way, yes, I better myself in every way. I make an honest effort to better myself in every way. I make an honest effort to better myself in every way. Yes, I make an honest effort to better myself in every way. Yes, I make an honest effort to better myself in every way. I believe in myself, and I have high self-esteem. Yes, I believe in myself, and I have high self-esteem. I said I believe in myself. Yes, and I have high self-esteem. Yes, I believe in myself, and I have high self-esteem. Hello, Jelana. Yes, who else do we have watching? Yes, high self-esteem. I believe in myself. You can go ahead and smash that like button. Yes. Waiting on a few more people. I'm sending out invites now. This is very last minute. I have very high self-worth. I said I strongly value myself, and I have very high self-worth. I strongly value myself, and I have very high self-worth. I said I strongly value myself, and I have very high self-worth. Yes, very high self-worth. Yes, very high self-worth. I said I strongly value myself, and I have very high self-worth. I watch. How are you doing today, Miss Jelana? And I watch my thoughts concerning myself. For my thoughts concerning myself come back to me, and my thoughts about myself create who I am. So I watch my words concerning myself, and I watch my thoughts concerning myself. For my thoughts concerning myself come back to me, and my thoughts about myself create who I am. Yes, they create who I am. All is well. Create who I am. My thoughts of myself. Happy first of the month. So I watch my. We're gonna get started in about 5-10 more minutes. Can you share it to the group, Jelana, please? So I take great care in making sure that I am consistently thinking positive. I take great care in monitoring the thoughts that I think and the words that I speak. I take great care in monitoring the thoughts that I think and the words that I speak. Yes, I take great care in monitoring the thoughts that I think and the words that I speak. I take great care in making sure that I am consistently thinking positive. I take great care in monitoring the thoughts that I think and the words that I speak. I said I take great care in making sure that I am consistently thinking positive. Yes, I take great care in making sure that I am consistently thinking positive. I love myself enough to create a better version of me. I said I love myself enough to create a better version of myself. I love myself enough to create a better version of me. I love myself enough to create the greatest version of myself. I said I become the greatest version of myself. Yes, I become the greatest version of myself. I love myself enough to become the greatest version of myself. I become the greatest version of myself. Yes, the greatest version of myself. So I am diligent in planning out my goals, and I am consistent with carrying them out. I am diligent in planning out my goals, and I am consistent with carrying them out. Yes, I am diligent in planning out my goals, and I am consistent with carrying them out. I am diligent in planning my goals, and I am consistent with carrying them out. Yes, consistent with carrying out my goals. I am consistent with carrying out my goals. Yes, I carry out my goals consistently. I say always do I carry out my goals. I say. Yes, I do. Yes, I do. I am diligent in cultivating a mindset of confidence within myself. Yes, I am diligent in cultivating a mindset of consistency within myself. I am diligent in cultivating a mindset of confidence within myself. I am diligent in cultivating a mindset of confidence within myself. Yes, I am diligent in cultivating a mindset of confidence within myself. Yes, I am diligent in cultivating a mindset of confidence within myself. I am consistent with doing daily affirmations. Yes, I am consistent with doing daily affirmations. I am diligent in cultivating a mindset of confidence within myself. I am diligent in cultivating a mindset of confidence within myself. I am consistent with doing my daily affirmations. I am consistent with doing my daily affirmations. I love myself more than enough to take good care of my mind and to make sure that it is in a healthy state. I said I love myself more than enough to take good care of my mind and to make sure that it is in a healthy state. Yes, I love myself more than enough to take good care of my mind and to make sure that my mind is within a healthy state of being. I love myself more than enough to take good care of my mind and to make sure that my mind is in a healthy state of being. I love myself enough to take good care of my body and nurture it with food that is healing and healthy. I said I love myself enough to take good care of my body and to nurture it with food that is healing and healthy. I said I love myself enough to take good care of my body and to nurture my body with food that is healing and healthy. I said I love myself enough to take good care of my body and to nurture it with food that is healing and healthy. I love myself so much. I am very much so in love with myself. I love myself so much. I am very much so in love with myself. I love myself so much. I am very much so in love with myself. I love myself so much. I am very much so in love with myself. I said I love myself so much. Now I can love others on the greater level. I love myself so much. Now I can love others on a greater level. I love myself so much. Now I can love others on a greater level. Yes, now I can love greater. Now I can love others on the greater level because I love myself. Okay. How did that happen? Who put that there? All right, so we're going to get started. Can everybody hear me? Please let me know if you can hear me. Yes or no. Put it in the chat. Okay, dokie. So let's go. So what we have here is an amended complaints from someone named Louisa against all these defendants, who is basically tied to a debt collection law firm regarding a rental collection. Let me make sure I put this over here. Hold on. Okay, yeah, that's zoomed in enough. Let's see. All right, so here we have, I'm trying to zoom in so you guys can see it a little bit better, but I think that's the best I'm going to be able to do right there. Let's see. All right. At any time, if you have a question, put it in the chat. And if I'm able to answer it, I will. If I'm not, I'll tell you why I'm unable to answer it. Please don't feel obliged that I have to answer every question you put, because I don't work for anyone but God. So let's get it started. So this is basically one plaintiff. This is against a whole debt collection law firm, as you see. And it's a jury demand.
You know, most people try to make sure they ask for a jury because you are entitled to a jury when it comes to a trial in these matters. So they're at them for, of course, you see the Fair Debt Collection Practices Act, which is the FDCPA. Hey, Justice, thank you for coming in and speaking. I love the respect that you have. The Fair Debt Collection Practices Act, the FDCPA, which I always talk about under 15 U.S.C. 1692. They're also integrating the New York general laws as well and other New York consumer protection laws for negligence and gross negligence. And these are punitive landlords, they are saying, for rent overcharge for violating New York law and negligence per se and gross negligence. Now, let's go back up. So this person was someone who lived in low income rent stabilized housing. Is anybody familiar with low income rent stabilized housing? If you are, some of this may have possibly happened to you, or they attempt to do this to you. So you might want to pay attention, or maybe you know somebody that you can be like, hey, I remember this case. You might want to look into it and try to learn your rights, you know, because that's the main thing. It's not about, the thing is, everybody want to help somebody, but you can't help somebody if they don't know their rights. That's the main thing. Now, they said she had $7,500 in rent from a landlord in an attempt to get long needed repairs, you know, done for her apartment. In response, the landlord, through the agencies, falsely claimed that Louisa owed more than $30,000 and sued on that amount. They was looking for eviction and a money judgment. So when she received the lawsuit, it says she paid the money she was withholding and the landlord gave her receipts saying that everything was up to date. Even though she did that, the landlord and the collection attorneys continued to vigorously litigate the lawsuit when they should have known that she never owed $30,000 and was paid what was owed within the days after being served with the lawsuit. They say collection attorneys and landlords regularly sue low-income tenants for amounts they do not owe in an effort to force them out of their rent-stabilized apartments. This literally just happened to one of my students. Let me make sure I can share this to her because it might be beneficial for her. Let me see. Okay, we are back. We're back. We're back. This happened to your place in VA? Wow. So this is on time then. So it says, they try to sue them to force them out their apartments, right? It says the landlord has inflated the rent over what is permissible pursuant to rent stabilization laws and administration codes, and they are liable for that rent overcharge. They got in there, their jurisdiction and venue, and they got the parties here. Let's go down. Let's go to the allegations. So basically, she's a New Yorker who resides. Hey, Bianca, thank you for coming. And thank you for coming in and speaking. I appreciate your respect. It's a New Yorker who resides in a 2-bedroom apartment with her children and grandchildren. Upon information and belief, they're letting you know it was a 4-story, right? They're going down. She lived in her apartment since 1997 when she first moved in. She recalls paying her landlord $750 a month. Mr. Tam, who was one of the landlords here, because remember, she got different defendants. Mr. Tam never got a written lease for the apartment and never informed her that the apartment was rent stabilized. So from 1997 to 2017, she paid her rent in cash, and he gave her rent receipts and filled out the information on the receipts, including the date and the month from which the rent was applied. So this doesn't have a lease. And everyone always says, well, what if I don't have a lease? What if I don't have a lease? You might want to pay attention. So they go on to say the rent increased over the years, and the rent increased to $1,095. Before, remember, it was $750 a month. And that was beginning in April 2011, beginning around April 2011. Then in 2014, the rent decreased, looks like by a few bucks, because now it's just $1,075. Over the course of more than 20 years that she lived in this apartment, there were serious problems that they would not repair. And they have here, there was a previous fire in the building, so the wood floors was damaged, and her brother installed the new floors in one bedroom in the living room. The stove was rusting, the pilot light would not work. But when she was told, when she told him about the problems, he said if she wanted to fix, the rent would increase. So she ended up dealing with it by herself and paid $400 to purchase a new stove and had it installed. There was additional issues as far as a leaking bathroom ceiling and things like that. Early in that year, she developed, her son fell down the stairs, who's developmentally disabled, and fractured his wrist when he tripped over nails that were protruding from the steps. Also, it says the 4-year-old daughter tested positive for elevated lead levels. Over the years, Miss Luisa speaks Spanish. She frequently asks her brother to translate and inform, let the landlord know what's going on. But of course, he failed to make any repairs. So she became frustrated. She called 311, which is a number in New York City that you could call if you have issues like that with your landlords and things, and they're supposed to rectify the situation. She called 311 to report the problems. She also began to withhold her payments. She saved the money she should have been paying rent every month and put it to the side. And that is the smart thing to do. If you're withholding money for a legal reason, do not spend it. Do not spend it. That makes no sense to spend it. She saved her money she had been paying rent every month and put it to the side, knowing she would give them the money as soon as the necessary repairs were made. And a 5-day notice she got received on August 21st. There was a collection agency that notified her that she was indebted to her landlord more than $30,000. It was supposed to be from May 2015 through August. And a notice advised her if she did not pay it, they would commence summary proceedings to recover possession of the apartment. And she attached the exhibit. Then she goes on to say on September 2017, the landlord, through the collection agencies. You notice how they did that? Do you understand why that language is so important? Anybody understand why that language is so important? Anybody know why that language is so important? Well, I don't know which one you're referring to, but I was talking about the one where it says the landlord through the collection agency filed non-payment proceedings. So it wouldn't explain emotional distress. That's showing a connection to how the landlord is this attorney is an agent of the landlord, and there's no way this attorney would have any of this information if it wasn't for the landlord. So they're showing the connection between those two. Because a lot of people may have several defendants, but you're not showing the connection to how they caused the emotional distress. So you're 75, like I would say 50% right, because you got to show the connection. You just can't say emotional distress. Remember, their conduct has to be in such a way that it caused it. But if there were several defendants, who did what to make what happen, if that makes sense. So they're talking about the rent stabilization laws in New York on paragraph 32 here. Louisa was confused to see that the LLC was seeking to collect $31,000 because she had only withheld 7 months of the payment. Around September 23rd, 2017, she tendered $7,000, an amount representing all the rent she had withheld. So remember, she only owed $7,525. Where did they get $30,000 from? You know what I'm saying? Where did they get 30? How did you even phantom to get, even if you add attorney fees and let's just say some sort of damages, how did you get from how much is it? 7,000 to 30? Like, that is beyond me. That is beyond me. Again, when she gave him the money, he gave her receipts that he filled out showing her the rent was paid. So again, despite the fact that she did not owe any additional rent, they still proceeded with litigation. So she appeared pro se on her own. Hold on, let me change this. She appeared pro se on her own the first time she came to court in October of 2017. There was someone named Justice McAllister who lived in the basement of the building, who was an agent for the property, and he came on behalf of the rental company. She asked her, why they suing me for so much money? And the property manager, like, you know what, I'm going to speak to him because he made copies of the receipts. He made copies of the receipts showing the payment of the rent, like everything was paid up. So there was a stipulation that was signed in court. The case was adjourned to give the parties time to review the records on the apartment. The petitioner also promised to make certain repairs. So I guess they had something in writing. Phantom numbers, absolutely. So now she retained a legal services, which is nonprofit legal service provider, to help represent her. So she appeared in housing court. Now, if you've been studying for some time, you notice paragraph 37 says Ms. Calixto appeared in housing court with her attorney. What is wrong with that paragraph? Not the paragraph, but what is wrong with that scenario? What would you have done different as a consumer that knows their rights when it comes to debt collection?
Today is going to be a good day. Yes, today is a good day. Today ended well. Today ended well. Yes. I got all of my goals accomplished today. I got all of the things done that I needed to complete on today. Yes, I got all of the things done that I needed to complete.
What would you have done different?
Yes, I did. I am thankful that I got all of my goals done. Yes, I am thankful. I am happy that I got all of my goals done. I am happy. I am happy. Yes. Everything is good. Everything is all right. I am making progress in all of my
just paragraph 37. Are we on it's not showing 37 up here. Why is it stuck on 32? Which paragraph do y'all see in front of y'all? Oh, there it is. It's on 37. So 37, where it says she appeared in housing court with her attorney. What would you have done different?
I am that. I am. Yes, am clarity of mind. I am on the vibrational frequency. I am on the vibrational frequency of peace. I am on the vibrational.
Absolutely, Bianca. Absolutely. 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 Yes. Yes, Justice. Absolutely. Absolutely. But she has an attorney, and she knows nothing about consumer rights. So of course they're in housing court. But that would be something you would do different. This doesn't look clear, does it? This is like blurry, right? Is it blurry for y'all? Or is it just me? But it's like it's a downloaded PDF, so I'm not sure why it's blurry. Is it blurry for y'all? Because I might have to try to switch it out and just share the screen and do it another way. Because this way, I was trying to just do a PDF instead of the screen, but I can share the screen if it makes it easier. Because it looks like it's blurry on y'all side. Because I have two monitors. So is it blurry? Like, can y'all see clear? Like, or does it look like y'all can't really see? I'm squinting really bad. On one monitor, I can see it clear, but when I'm looking through YouTube, it looks like it's blurry. Okay, you can see it? Okay. Oh, it's clear. Okay, cool. Let's go. All right. So, in spite of the judge's instructions on the previous court date, neither the landlord or the attorney had reviewed the records. And again, the case was adjourned to a different date. Then there was a snowstorm, and they had to get adjourned again. The housing attorney sent the collection agency a letter attaching the rent receipts, saying that she's been paid up and asking them to discontinue the lawsuit. The collection agency ignored the letter and the evidence attached. So the housing attorney, this is a housing attorney that she got through their legal services through nonprofit. The housing attorney also subpoenaed records regarding the apartment building from New York State Division of Housing and Community Renewal. In response to the subpoena, they issued documents stating there is no record of registration statement on file from 1984 to present. It was never established. At some point during the course of the proceedings, the collection attorneys provided Ms. Calixto housing attorney with rental breakdowns. However, the breakdowns incorrectly alleged that she had not paid any rent, despite the fact, again, that they got receipts. Her attorney motioned to dismiss the case on the grounds that the rent demand and petition were defective and that they failed to credit her for money already paid. Already paid. Hold on, let me get this off of here. Hold on, let me go back. All right. Already paid. So we on paragraph 46. It says, despite their representation that they would discontinue the action, the collection agency in fact served an affirmation in opposition. They falsely represented that there was no defects in the petitioner's rent demand and such good faith estimate of the amounts due at the commencement of the proceeding. They did not attach any rent records, did not address the fact that she paid what she did, and they did not address the proof attached to the motion showing that the apartment was not registered and did not include an affidavit by someone with personal knowledge acknowledging the amount allegedly owed. Confused as to why the collection attorneys would write opposition if they were going to discontinue the case. So the attorney reached out and see if they were still planning to discontinue. They said they was, but their actions pretty much wanted the other client. It's like so many defendants. They wanted to proceed. They want to keep going. So they did not discontinue the case, but they filed opposition in the motion to dismiss. They objected to it. And they about the registration statement, they basically said that the landlord will eventually register it. And when a judge asked why the apartment was not already registered, he ain't have an answer. The judge reserved decision to read the parties' papers. So then the judge granted the motion and dismissed the action. The court held that the multiple dwelling precludes the collection of rent and the building is not registered. Did y'all even know that? Did y'all know that if you live in a certain building, it had to be registered with a certain agency in order to collect anything? Are you guys familiar with that? If you want a copy of this case, you guys can get it. Since you want to buy me a coffee, just send me an email and I can make sure you get a copy of this case. See, this is why I always tell you guys to continuously study, things that's pertaining to your case. Because, depending on where you live, there may have to be a registration to make sure you can collect. Just like an attorney, in order to collect in certain states, you got to have a license to collect. You see what I'm saying? But when you research and you read, these are things you find out instead of just trying to y'all know what I mean. Now, so despite the fact that the building was never registered, Miss Calixto continued to pay $1,000, per month. So the landlord and the collection attorney schemed to force out low-income tenants. The misrepresentation by the landlord and the collection attorneys to the consumers and to the council of Mount Zoo are not unique in this case. Yes, you can. Absolutely. If you know it's required, absolutely. That's why I say it's the legwork that you have to do in order to build your own case. Because again, everybody's case is going to be different. So say for instance, a regular Schmo Joe may come past this video and the next week or two, and they're going to say, oh, I can use the same laws and do this, but they live in a house. And they're going to try to use, hey, Olivia, they're going to try to use all these laws, but they live in a house. You know what I'm saying? Or the building is registered and they're like, oh, but what if mine? You know what I'm saying? So it's no what ifs. It's utilize your own case, find your own facts and present them. There's no two cases that are the same. That's why, you can't do monkey see, monkey do. And that's why it was someone who misrepresented their audience on social media by telling them that they use consumer law or other laws to retrieve a vehicle back, knowing they had someone that worked there to lie for them. But then they decided, oh, since I did it, let me go ahead and create a class just on repossessions. Then everybody in the comments is like, oh, I took the class and it's not working. It's not working. It's not working, because everybody's state is different. Everybody's facts are different. Some people got people behind the scenes that y'all don't know. So you can't just say, oh, they did it, I can do it too. That's why, again, I'm going to keep saying until the day I perish this earth, there is no process. Mr. Tam is the owner of the building on Prospect in Brooklyn, and they got all these buildings. They believe he got 8 residential units. The buildings have serious repair issues they're talking about. Because remember, this is housing. So again, when you're in housing, you have other protections. There's more protections that you have when you're in housing. Because HUD is the governmental agency, that supports and governs these things. So then it goes down to say Mr. Tam, he hired a collection agency to file a bogus residential landlord-tenant case to evict tenants for non-payment of rent. Sometimes the cases are filed with Mr. Tam as a petitioner, and sometimes the LLC. Isn't that deceptive? And sometimes Mr. Tam and somebody else are listed. There is no rhyme or reason who is listed as a petitioner, and a tenant can be sued by Mr. Tam and an LLC within the same year. However, in all instances, the collection attorneys represented the petitioner. In all instances, except for one, the managing agent, Mr. McAllister, was a managing agent for every building on the HPD website. So the legal services has attempted to review every residential landlord case based on non-payment of rent. So they went through and looked at all his cases. Let's wait a minute. Let's see if he's done this to somebody else. Again, proven gross negligence, a pattern of behavior to say, okay, because their objection normally has something to say, oh, there's no way we would do that. And look at our website. We have values and morals and integrity. We do this. But if you've done this within a year to 50 people, is what you're saying is true? Or your character speaks for what you've already done, right? So They go on and say that there was a disturbing fact pattern. I like that, a disturbing fact pattern. You know, it was a common defense in housing court with a money judgment for possession of generally limited to 6 months to a year. So after a few court dates, the case is eventually discontinued without prejudice, with no evidence of money being paid. And this is his previous cases, not this case. They went back and they're talking about his other cases. So all his cases that he had filed basically had the same premise, that they didn't pay no money for a certain amount of months. That's basically what they said. It says, simply put, on paragraph 59, it says, Mr. Tam and the collection agency, attorneys are lying to the court and to the tenants about rent being owed in order to wear them down and intimidate them into moving out of their rent stabilized apartments. It's crazy work. This is just more facts about the other people that, you know, they naming the people. See, Raphael, they talking about the cases, whatever. So this is really good how they really broke this down. I like that. They took every person that was sued, they brought it in because it's public information, is it not? It is. It's public information. So here's the public information of every case, and they put in there what they allege. You know, same thing, the same behavior. They proved a pattern of fraud pretty much upon the courts. It says, upon information and belief, Mr. Tam and the attorneys have know or have reason to be aware of the defects in their notices. The law firm failed to conduct a meaningful attorney review of the documents that would support collection of amounts owed. For example, it says the collection attorneys properly sought out and reviewed rent ledgers, the HCR records, and leases. These mistakes simply would never occur. Then the attorneys realized or consciously disregarded. Remember 1692F. Remember, it talks about this. 1692F talking about how unconscious the decisions they make that's unfair is unconscionable. They talk about this. So in this case, the defendants knowingly brought a lawsuit for significantly more than an amount that was due, and more to the amount that they were legally allowed to collect. Defendants made the conscious decision to continue litigation for more than 6 months after all the rent was paid, after they were on notice that they had no basis for continuing excuse me, the litigation. And of course, they're talking about the motion to dismiss and things like that. So they're going through the facts of the case, but like right here, it says Ms. Calixto is precisely the type of the vulnerable consumer that the FDCPA was designed to protect. This is the whole concept of the FDCPA. It's designed to protect you, and you're vulnerable because you do not know. It says her life has been severely affected by their actions. Remember, their conduct, their behavior. The defendants caused her to sustain actual damages, including out-of-pocket expenses to investigate her case, travel back and forth to court, meetings and consultations with attorneys. Moreover, the mental anguish and stress she experienced as a result of this lawsuit has plagued her for almost 1 year and continues to this day. Right? It says now this is part of the emotional damages stuff, Justice. When she first received the petition, she couldn't understand why she was being sued for $30,000 when she only withheld, 7 months, which was $7,000. She was extremely stressed by the amounts they were seeking to collect, and she worried constantly that she and her children will be evicted and become homeless. She worried every day that a marshal might come physically and remove her from her family and from the apartment into the street. This fear led her to suffer from severe sleeping problems. Most nights she would lie awake thinking that what would happen to her happen if her and her family had to leave and where they would go. She cried frequently throughout the duration of her court case, and while she tried her best to hide her stress and fear from her children, they were understandably affected. Her children would ask where would they go if they were evicted? What would happen? She told her children that the family would probably have to live in a homeless shelter. Her children were scared. They did not know what to think, and they were worried how they will be able to return to school if they had to live in a shelter. This is constitutional violations. Life, pursuit of happiness. Life, liberty, pursuit of happiness. Is it making any sense, guys? Is this making any sense, guys? She says, I love it. Show how she was emotionally damaged under the facts and how it's relevant to the case. Absolutely. You see how they explain how it was relevant to this case. Not because everybody could say, I have mental anguish. I can't sleep. I've seen a therapist. But how broad is that versus how they detailed this out right here? Right? Again, that's why I always try to get you guys to, I always say not play the victim, but remember you're a victim and you've been victimized. So you got to remember that. And when you're a victim, there's details. Remember, if something happened there, if a crime happened and there was a suspect, they're going to ask you, they're not going to say, what did this, how tall was the suspect? You know, anybody could be tall, but what color was his hair? What shoes did he have on? Well, no, what was his race? What was his eye color? Did he have any tattoos? Any marks on his face? They are details in order to pick somebody up out of a lineup. Or say they did anything. Hey, Miss Henry. Right? So I can't write everything for y'all. I've never written anything for anybody, but some people feel that, hey, can you just tell me what to write? I can't tell you what to write. I didn't feel what you felt. You see what I'm saying? I don't know the conversations you had. Like, for instance, Justice with the case with her cousin with the Consumer Report. They got into a whole argument. Who knows what they discussed? What if they broke up? I don't know. But that is a damage that probably no other person could probably utilize in their case. She said, you are God sent. Thank you. I appreciate that. I appreciate that. I appreciate it. So let's keep going. It said, her worries, distress, and sleeping problems persisted so long after she gave him the rent payments that she had been withholding. Defendants continued to litigate the case for more than 6 months and confirmed to allege she owed money dating back to 2015, even though she did not owe the money. She was concerned that her landlord would somehow win the case. Mr. Tam told her that he had good lawyers. How many times y'all heard that? They're like, oh, we got a good lawyer. We're a good law firm. Who cares? You think I care about your law firm being good? If it was that good, you'd be the only one in the United States of America. Mr. Tam told Ms. Calixto that they had good lawyers and she was afraid he would win in court, even though she did not even though she didn't owe the money. So they went to housing court. She noticed that it was not the same attorney appearing. I think this happened to somebody else. It was not the same attorney appearing for Mr. Tam at every hearing. She knew Mr. Tam owned several buildings in the area, and she worried because he had the money and several good attorneys that somehow he would win a case and her family be left up without a place to live. Ms. Calixto still sometimes has difficulty sleeping when she thinks about the stress of everything that has happened with her apartment. She also claims as actual damages the reasonable value of her attorney's time and labor to investigate the case and obtain a favorable resolution. Now here come her FDCPA claims. And on the website, they say we are feared. Exactly. And that's public information you can utilize against them. You know, especially when someone says some stuff like that, you know. So again, they talk about the claims on the FDCPA, and this is just for the collection attorneys. Now, notice that's why it says claim for relief as to the collection attorneys. So the purpose of the FDCPA, we already know that, and they got all the case law here. You know, state action to protect consumers. They already know unfair, deceptive. You know, they got all that stuff. What Congress designed the FDCPA to be enforced primarily through private parties, such as the plaintiff, acting as who? Private attorney generals. And this is a congressional record. Do y'all guys see this? The FDCPA enlists the efforts of sophisticated consumers like plaintiffs as private attorney generals to aid their sophisticated counterparts. How many times y'all heard me tell you you're a consumer protection officer? How many times I told you you got the power and they have none? But then you got people on the internet that's going to tell you you're an attorney in fact and you believe them. I'm an attorney in fact. I'm an attorney in fact, ma'am, judge. I'm an attorney in fact. I seen some on TikTok and they you could tell they messed up. He had the guy with the glasses. I don't know if y'all seen it. It was a video about like one of them sovereign people, whatever, Moors, whatever. I don't know what they call themselves nowadays. They changed it up so much. But he had glasses. It was him, and then he had to do. He's like, I'm an attorney general. How you an attorney general, sir? And you up here talking about secure party creditor in all caps name. The only private attorney generals are natural people. Us. So if you don't claim you're a consumer and a natural person, how the hell you a private attorney general or anything? Right? So the defendant's actions of the defendants constitute attempts to collect the debt or were taken in connection with the attempt to collect the debt within the meaning of the FDCPA. They violate the following sections and they put what sections they violated. Then they went to the second relief of New York, right? Remember we talked about this in the beginning when they had their claims of action. They got the New York General Business Law prohibits the same thing. Deceptive acts or practice in the conduct of any business, trade, or commerce. Commerce is a key word here. Or furnishing of any service in this state. So the people that went to the mentorship, I broke down whatever state they was from when they registered so I can make sure they have their state laws so they'll know how to move if they're going to add their state protections along with their federal protections, just as Ms. Calixto did here. So it says an individual. So what does the business law also say? It says an individual injured by reason of any violation of this section may bring an action in his own name, right? An action to recover his actual damages or $50, which is greater. This is New York General Business Law. And an individual may be awarded punitive damages. That's where the money comes in. Punitive and actual damages. So they also have what? They said they have, they violate the business law by using deceptive acts and practices to conduct their business and have broad impacts on consumers at large. Because remember, they went back and showed their negligence over the years. They had a pattern and practice of attempting to evict tenants by misrepresenting the amount owed and legal regulated rent and actively concealing from the consumer and the courts the amount that had already been paid. Now they're going into the judiciary laws. It's a third claim for relief. And again, this is just for the collection attorneys. And again, I always said, I tell y'all all the time, New York State. People always say, oh, y'all people down south, y'all think y'all can just do everything. Not in New York. Y'all just don't know how good y'all got in New York because y'all think y'all New Yorkers. And I'm a New Yorker myself, and I'm saying that. So New York judiciary law creates a private right of action against each attorney or counselor who is guilty of any deceit or collusion or consents to any deceit or collusion with the intent to deceive the court or any party. The collection attorneys, they violated, by filing and continuously to litigate and misrepresenting an amount that was not owed. The fourth claim, this is now to the landlord. Now, if they dealt with the collection attorneys, now they're dealing with the landlords. So this is their fourth claim, rent overcharge. So in New York City, the residential rental units occupied by the primary residents were built prior to 1974. Remember, they were talking about the registration. Remember, they had to be the registration with the DHCR. They did not have it since 1974. And that's the admin code for the building. So what they talking about, the failure to file a proper, timely, initial or annual rent registration. Same thing with the banned debt collectors list. They may be banned and still trying to collect the debt from you. That's just the legwork you have to do, right? Then they go in to the fifth claim. They got negligence. This is to all defendants. All the defendants. It says, let me go back. Let me get that first part of that thing. It says, defendants owe Ms. Calixto a duty pursuant to the FDCPA, which is designed to protect consumers and prohibiting debt collected from using false, deceptive, or misleading representation, means, the character, amount, or legal status of the debt. Using false, deceptive, misleading. Y'all already know what this means. Creditors and debt collectors in general owe debtors a duty of reasonable care. This is the reason why, what's her name? I think Bianca said, yeah, I would not have got an attorney. But okay, in this case, she's on housing I mean, she's had rent stabilized, so she's in housing. So it was free, so it was good for her. But to see what they notice how they called her out her name here, but it's okay because this is how they worded up. But as for you as a consumer, you know you're not a debtor. You know you're not a debtor, right? That's why I say all case law ain't good, because somebody may tell y'all this case law, Hawkins versus First American, and they be like, they got you as a debtor, and you over here talking about you're a consumer. You don't even know because you ain't read the case. You just banking on case law because somebody made a statement. So defendants breached the duties, including by misrepresenting the amount, to her, failing to disclose the amount that she had actually paid, misrepresenting the apartment was registered, and that the rent demanded did not exceed the legal. And anybody, don't pay your rent in cash. If you got to pay your rent in cash, you might as well manipulate your credit report and get you a real apartment, because you are going to get scammed like this lady right here. Cash is not a way to pay rent unless you're paying your mama in her house, like dead ass. There's so much shit going on nowadays. I'm telling you, better have some sort of legality around here. It was the apartment was registered after they had actually paid. They breached the duties, they said. So honestly, if I was her, and again, she's an old lady with grandchildren, so it sounds like she's a little older, but then nowadays grandparents are 30, so I don't know. But once this case was over, oh man, she had a whole different what you call it, lawsuit, against the housing authority. And again, I have to look into how, some apartments allow you to just move in, and some, depending on what you got, Section 8, they have to do an inspection. How did it even pass? Like, how did it get past housing? If y'all paying rent to a landlord, you know what I'm saying? If I'm getting this money, how are y'all knowing y'all don't know who these people really are? She said, but they all paperwork they give us states consumer, but as soon as they sue us, we're up to absolutely deception. So she wants a jury. She says, as a result, she's entitled to a punitive damage award. They didn't put the amount, but they want statutory damages on the 1692K. Other awards for attorney fees on the 1692K. The judiciary laws. They want to enjoin the defendants to cease violating the GBL laws and any other law and relief in equity, both special and general, to which the plaintiff may be justly entitled. Justly entitled. What y'all think about that? What did y'all think about that? Any questions? Anybody got any questions, comments, or concerns?
All right. Peace, love, and power. So, a lot of people were wondering, how does APOC reprogram his mind? We talked about the different ways of programming the mind, but some... If I can get everybody to hit the like button, that'll be awesome. I would really appreciate it. We want to make sure a lot of people see this, because again, our people suffer from the lack of knowledge, the lack of wisdom, that they don't know. So maybe this may reach the right hands. If you like it, share this video on your social media if you can, because it will be on YouTube afterwards. So if you can go out and hit the like button on YouTube, that'd be awesome. I would appreciate that. Absolutely, Justice. And in the language too. Some of the language is really good. And then a lot of people not aware of that deception. Like she said, she's like, wait a minute, I just only withheld 7 months. How this number? Where you get this number from? And she found out by doing some studying and some extra legwork. Like, let's see who else they did it to. They went to housing court with an attorney. Went to housing court and found out like they've been suing people like this for years and been getting over with the same thing, and they're lying. So she can actually hit them with a Rule 60 for fraud upon the court. Sure can.
I am. Today is going to be a good day. Yes. Today is.
Anybody got any questions before I head out of here?
Yes. I got all of my goals accomplished today. I got all of the things done that I needed to complete on today. Yes, I got all of the things done that I needed to complete on today. Yes, I did. Yes. I did. I am thankful that I got all of my goals done. Yes, I am thankful. I am happy that I got all of my goals done. I am happy. I am happy. Yes. Yes. Everything is good. Everything is all right. I am making progress in all of my goals. I am thankful that I am making progress in all of my goals. Yes. Yes, I am. I am excited about life. I am motivated to complete every goal that I have. I am motivated to complete every goal that I have. I am motivated to complete every goal.
Hey, Moni, we just finished up. I was seeing if anybody had any more questions. And this video will be on YouTube, so you can go back and watch it. Thank y'all who went out and liked the video. I appreciate that so much.
I am wealthy. I am healthy. I am successful. I am prosperous.
I know. I got banned from TikTok for a day, so I had to go live. I'll be unbanned tomorrow. It was my fault this time, y'all. It was really my fault. Normally it'd be TikTok fault, but it was my fault. I was driving. But I had a filter on, but I guess they saw the filter. I guess TikTok could see if you got a filter on or not. Okay, no one has any questions. I thank you all for coming. I might come back and do a late night session. I don't know. Make sure your notifications is on. Because I heard, TikTok is phasing into something called Lemon 8, and I don't really care for that. I'd rather go ahead and get my YouTube channel where it needs to be. Because I've had YouTube since 2017, 2018, but I just have never done nothing with it. I randomly upload a video because I forget about it so much. So I will be on here, and then once I get everybody over here, I know we have Buy Me a Coffee. Buy Me a Coffee will phase out, and I will just do YouTube. Once my channel gets to where it needs to be, I will do the membership on YouTube. So then it'll be member only live. So if you're not a member, you won't be able to watch the lives, but it'll be just like how we do on Buy Me a Coffee, but it's just easier because it's YouTube. It's just an easier platform, and everything will still be included. And Justice, I told you to hit me up. You said you want to do your one-on-one. I think that was you. Email me. I'm available Thursday if you are. So just email me and we can go from there. And I'm gonna end the video, end the live. Thank you all again for coming. And I think I should be unbanned tomorrow on TikTok. So I won't be live tomorrow into the evening or afternoon because I have some stuff to do in the morning. And then I have my mentee I do in the morning on Mondays now. So I'll have to, do her session. The mentees get an hour, maybe up to 2 hours, depending on what they're doing per week. And she just shows Monday. So that was the only day I had left over. But one of the mentees is about to phase out because it's only a 60-day program. So one of them is about to phase out. Then I have room for some more. But y'all have a great day. I love you all. Peace.
Yes, I do. Yes, I do. Yes, I do. I do know how to receive love. I do.